Hello everyone, welcome back. In this video, I'm going to talk to you about the difference between the Baker Act and the ex parte. So let me explain this, okay? Because this came about as a result of a call that we got from a family who had a family member that has about a 10-year history of substance use, mental health issues, mostly mental health issues. And the family member that called me said that he had been speaking to a clinician and another lawyer, and they said that you should file the ex parte and then you should file the Baker Act. And I said, the ex parte is the Baker Act. And he said, no, they're two separate things. So I said, if you don't mind, can we take a few minutes so I can explain this to you? So I'm going to share with you what I shared with him. And just so we're clear here, there's an ex parte section for the Baker Act. There's also an ex parte section for the Marchman Act. We're talking specifically about the Baker Act because we're dealing with a mental health issue. And remember, the Baker Act specifically excludes substance use. So you can't Baker Act somebody, not legally anyway, for a substance use disorder. That's why we have the Marchman Act. And I said, look, there's three ways you can Baker Act somebody. Number one, you go to court and you file a petition, an ex parte petition, for assessment under the Baker Act. And if the court grants it, the court is going to order the police to go and get your loved one and take them to the nearest receiving facility. So that's the first way it can be initiated. The second way is law enforcement. You call the police come down, and they make a determination that your loved one meets criteria, and they take them without a court order to the nearest receiving facility. Or the third way is when a qualified professional issues what's known as a professional's certificate. For instance, a licensed clinical social worker. An emergency room doctor makes a determination that your loved one meets criteria. They issue what's known as a professional certificate. It's a 1 or 2 page document where they basically swear to the fact that your loved one meets criteria, and now you become a temporary ward of the state, or your loved one does. And so there are three ways to initiate the Baker Act. All three ways result in your loved one becoming a temporary ward of the state of Florida, which means your rights to make decisions for your loved one, even if they have executed a healthcare proxy and or a power of attorney, are terminated. In other words, you don't get to make any more decisions now because you just handed your loved one over to the state of Florida. They've taken custody of them. They've become the guardian. And I said to him, well, and then he said, well, we're going to file a Baker Act afterwards. I said, you're not going to be filing anything. Because once the court grants that ex parte, now your loved one can be involuntarily held for up to 72 hours. And after 72 hours, one of three things is going to happen. Number one, he or she is going to be released. Number two, somehow they give voluntary consent to remain at the facility they've now been taken to. Or number three, the facility files a petition for involuntary placement. In other words, asking for a court order to extend the detention of your loved one potentially up to 6 months. And here's the deal. You, as the person that went to the courthouse and filed that request for an ex parte order, are not a party to this. It's the state of Florida versus your loved one. You'll be lucky if you even know about the hearing, and you'll be even luckier if you get called as a witness. This has nothing to do with you. You're not a party to this. So when people tell me they're going down to the courthouse to file an ex parte, and someone is telling them that that's a good idea, I have a problem with that. Okay, because look, here's the deal. The Baker Act is designed for emergency situations only. If it's such an emergency, call 911. If you have time to go to the courthouse, fill out the paperwork, wait for a judge to issue an order, wait for the cops to come and get your loved one, then I don't know if you really have an emergency on your hand. Or I think what you have on your hands is a guardianship case. And you need to file for a guardianship for your loved one so that you can make the decisions to save them, to get them into treatment, right? Have control over their finances and property and access to their medical records so you can help to make decisions. But if you Baker Act them, first of all, their rights to make decisions for themselves are terminated. Your rights to make decisions for them are terminated, even if you have a healthcare proxy. The state's power is absolute. They can ignore any documents that you have. Any authority that was given to you by your loved one can be ignored. And so I said to him, look, you need to file for guardianship. And my understanding is For right now, they're not ready to do that. And okay, look, this is a no judgment zone. I give advice, I give counsel, I tell you what I think, and then you decide what you think is the best course of action. But the ex parte is the Baker Act, okay? And once the court grants that, you don't now have the authority to go and ask the court for an extension. It doesn't work that way. You're no longer a party to this. It's the state of Florida. So please, please, please stop trying to use the Baker Act to get your loved one help. If it's an emergency, call 911. If it's not an emergency, then there has to be a separate course of action. So I wanted to share that with you. And with that said, thank you for tuning in. Please give me a thumbs up if you like the video. Please subscribe so you get notification of more of these videos. And I will see you in the next one. Take care. Bye-bye.